Good morning, good afternoon, and good evening. Welcome to Course 2B of the Monique and Roland Vale People's Academy of International Law. I am Marjorie Cohn, Dean of the People's Academy of International Law and a member of the Bureau of the International Association of Democratic Lawyers. In Course 2A, we presented the United Nations International Court of Justice and compliance with international law. Our topic for today is United Nations organs, their respective roles and competencies, and supporting people's struggles. Our faculty members for this course are Kojo Koram, Nadia Ahmad, and Dinorah. Each of them will speak for about 40 minutes. Then they will briefly respond to each other's presentations, and then we will have questions and answers with the registrants. We have French, Spanish, and English translation. Please put your questions in the Q&A box at the bottom of your screen for our discussion following the program. In the next few days, we will post the faculty presentations in English, French, and Spanish on our website, peoplesacademy.net. Kojo Koram is a writer and an academic, teaching at the School of Law, Birkbeck College, University of London. Born in Accra, Ghana, and raised on Merseyside, Kojo is now based in London. He was called to the Bar of England and Wales in 2011 and received his PhD in 2017. In 2018, the Association for the Study of Law, Culture, and the Humanities awarded his PhD the prestigious Julian Maisy Award. In addition to his academic writing, Kojo has written for The New Statesman, The Guardian, Dissent, The Nation, and The Washington Post, and he has appeared on CNN and Sky News. He is the editor of The War on Drugs and The Global Color Line, published in 2019 by Pluto Press, and author of Uncommon Wealth, Britain and the Aftermath of Empire, published by John Murray in 2022. Kojo will discuss how international law can be used to end the war on drugs. He will look at the role of UN organs in creating the war on drugs and explain how different forums, from regional peace and justice tribunals to the World Health Organizations, are looking to repair the huge damage produced by this war and ask what role the International Court of Justice and other organs could play in this effort. Nadia Ahmad is associate professor at Barry University School of Law, where she teaches environmental law, energy law, property and business organizations, and leads the Environmental and Earth Law Honors Certificate program. Her path-breaking research on climate cages has examined the intersection of climate policy and incarceration, arguing that policy responses to the climate crisis are designed to lead to arrest, detention, land displacement, job loss, and death, instead of actual solutions to the problem. Nadia's expertise has been recognized globally through her role as an expert advisor to the International Bamboo and Rattan Organization's Task Force on Bamboo for Renewable Energy and the External Affairs Committee of Solar Cookers International. She also serves on the International Bar Association's section of Energy, Environment, Natural Resources, and Infrastructure Laws Academic Advisory Group. Domestically, she serves as a council member of the American Bar Association's section of Civil Rights and Civil Justice, co-chair of the ABA Task Force on Environmental Justice, and fellow of the American Bar Foundation. In 2023, Nadia was part of a global coalition that was awarded the coveted United Nations Human Rights Prize for its advocacy in the right to a healthy environment by the General Assembly. Nadia will discuss international rulemaking, the so-called rules-based system, the role of the International Court of Justice and international environmental law. And she will explain inside-out reform, a model for activism and the role of public opinion. Dinorah Lalus holds a PhD in history and an LLM in comparative and international law. She has been active as a board member and consultant of public international law for various human rights NGOs for more than 15 years. Dinorah has served as commissioner for the Human Rights and Constitutional Rights Commission of the Puerto Rico Bar Association. She sits on the advisory council and executive committee of the American Association of Jurists and is a member of the editorial board of the Review of the International Association of Democratic Lawyers. Dinorah has done extensive work drafting statements for submission to the United Nations Human Rights Council in Geneva and to the UN Decolonization Committee in New York. She has also worked as a research assistant and professor for various academic institutions. Dinorah is currently working as an editor at the University of Puerto Rico. Dinorah will discuss the case of Puerto Rico under the United Nations Charter and the treaty system. She will cover the Trusteeship Council, the General Assembly, special agencies, and rapporteurs. And she will explain ways to further the Puerto Rican people's struggle for the right to self-determination and the right to development. Kojo?
Brilliant. Okay, I'll start up. I will share my screen and lead the way from there. Could I just get a quick nod to make sure that screen is coming over okay? For everybody? Yeah,
Looks
that's
good.
Brilliant. I will full screen as well. There, now we get the full effect. First of all, just wanted to start off by saying thank you to Marjorie and everybody for inviting me to be part of the faculty for this course. You know, this is such a fantastic project of public education around international law, demystifying the often quite obtuse and technical image that international law has in the minds of the general population. And I think it's such an important vocation to try and bring people into the language, the techniques, the forums, the arenas, and the ideologies to a larger or lesser extent of international law, because they have so much impact on our day-to-day life, you know, at a material level as well as a ideological level. And so it's great to be part of this project. What I'm going to speak to everyone today about is about the relationship between international law and war, a war that people might consider to be a kind of metaphorical war or abstract war. You know, we have for the last 50 or 60 years become familiar with this phrase, the war on drugs. And often people think about it simply in rhetorical terms. This is something that politicians say in order to present themselves as being tough on crime. But in reality, when we talk about the war on drugs, you know, we are talking about damage on human life that is comparable with what might be a kind of UN Security Council resolution recognized war. You know, when we think about the rate of death that's associated with the war on drugs, we might look at somewhere like Juarez, Mexico, where, you know, the rate of death would exceed that of somewhere like in Afghanistan. This was measured during the period of 2006 to 2012. So Afghanistan officially at war, somewhere like Juarez, Mexico, not officially at war, but yet with a much higher death rate. And then when we go to towards thinking about, statistics around incarceration. We can see how the war on drugs has facilitated the human warehousing of often racial minority populations, most famously in the United States of America, but also replicated in jurisdictions from Brazil to Colombia to the United Kingdom, and a lot of other places. And then we can think about the environmental devastation of the war on drugs and how that's been, and that will obviously be spoken about, the environmental aspects, by some of my colleagues a little bit later. When we think about the devastation on the earth that wars facilitate, the war on drugs has done that and more. We're talking about area fumigation policies that have devastated agricultural land in, say, the Cali region in Colombia. We're talking about crop eradication processes that have made it impossible for agrarian farmers in many different corners of the world to be able to ever grow anything on that land again. Um, and so I wanted to, I think, start off by challenging people's assumption of the war on drugs as being something metaphorical and abstract and not something very real that people really do experience as a war. And also to think about the way in which it shifted our ideas of what it meant to have a war. The war on drugs precedes the war on terror and, maybe the kind of data wars of the future, in being the first war that kind of breaks with the post with this kind of standard Clausewitzian idea of what a war should be, this kind of notion of, demarcated military, fighting demarcated military with kind of standard recognizable goals and aims, this ambition to separate the space of the public and of civilized society and the place of military conflict. With the conclusion of the Second World War, we might say that now warfare has emerged into what people like Hart and Negri and others have described as new war. War where there's a blending between police powers and military powers. There's a blending between surveillance and citizenry. There's a blending between who's an enemy combatant and who's a civilian. These things start to merge into each other, and there's also a kind of endless, perpetual nature of war that occurs. There's not a specific objective that needs to be achieved in order to bring the war to an end. It just goes on forever, and the war on drugs, I think, set in stone a lot of the kind of ideas around war in the late 20th and now early 21st century. And in terms of, things like wiretapping, in terms of things like surveillance that were rolled out in the war on terror, many of them were lifted or at least legislatively, the pathway was created through the war on drugs. And so not only do I want us to think about it as a war, I want us to think about it as perhaps the first instantiation of a new type of war. And that brings us to thinking about, well, what's going to happen in the 21st century when this war seems to be moving towards a new stage or towards a new instantiation. So that's what I'm going to talk about today. But first of all, starting with kind of historicizing and denaturalizing our idea of drugs. We often think about drugs as though this is a scientific category that has existed since time immemorial. If you went back to antiquity, people would consider the same things drugs that we consider to be drugs to this day. But this is very much not the case. And, a couple of the quotations that I've shared there, I think, illustrate that. The historian Roy Porter reminds us that if we went back just 200 years ago and talked about the drugs problem, no one would have known what we meant. This concept of drugs, and this is, really well kind of articulated in Jacques Derrida's wonderful essay, The Rhetoric of Drugs, where he says that the concept of drugs presupposes a kind of institutional definition, but there's a history required to produce that. There are laws, there are conventions, there are norms that make something like opium a drug and something like tobacco a commodity, or something like coffee a commodity and something like cannabis a drug. These distinctions were not something that existed in antiquity. They were produced in a very juridical and very recent history. And that's what I think we need to try and hold on to. Some images there as part of that slide include, the manufacture of opium in British India, which was, seen as a tradable commodity by, you know, huge corporations who are now, mainstream as they come. We can see, opium prescriptions there being given out. We can see that same for cannabis and for cocaine if we go back just to the 19th century. Never mind if we go back to, the Amerindian communities of the Andes, pre the encounter with the Iberians. Never mind if we go to, the whole of Africa and their relationship to different stimulants and substances, whether that be, coffee, which has now become mainstream and seen as a commodity, or whether cat, which is very similar plant that's grown, but it's very much categorized as a drug due to its relationship with those networks and conventions that Derrida mentioned. And so, Derrida, earlier in that essay, The Rhetoric of Drugs, has this idea that there is no such thing as drugs in nature. There might be natural poisons, but this idea of drugs, this idea of these particular psychoactive substances that are so dangerous to the human that the mere consumption of them once could lead to the breakdown of society, is for Derrida and for myself a recent history that has been produced through and by the law, particularly international law, starting with the 1909 Shanghai Opium Commission and then accelerating towards the 61 Convention on Drugs with the United Nations. But we'll get onto that story a little bit later. And so just reminding us that a lot of the same international powers who have been banging the drum for the prohibition of drugs, the war of drugs over the 20th century, just a century or so earlier, were the very same people profiting from drugs. When we think about the kind of doyen, the canonical figure of kind of Western liberal thought, we might think about John Stuart Mill. And in his book on liberty, he describes that the restriction on the production and trade of opium as itself being an evil. And here, of course, he's talking about this in relationship to the opium wars, which were being fought at the time. That was a war for drugs that was being fought by the British Empire and its corporate subsidiaries, or maybe by the empire and its British national subsidiaries, perhaps more accurately. For people unfamiliar, the opium wars in the early 19th century were when, following the imbalance in trade that had been struck up between British merchants, most notably the East India Company, still, according to a William Dalrymple or a Philip Stern, the largest and most powerful corporation that's ever existed. They got into a trade imbalance with the ancient Qing dynasty of China because they were buying products from China but had nothing to sell them and wanted to force the purchasing of opium by their Chinese trading partners. This was opposed due to it seeing as European incursion into the ancient Middle Kingdom for the first time, and a prohibition was placed on opium by China. And the response to the attempt to control drugs, to ban drugs, was a war by Britain, to a large extent by the East India Company and places like Jardine Matheson as a subsidiary, lobbying Lord Palmerston to send the British Navy in order to devastate China and, make Hong Kong part of Britain and have this whole world-changing moment. This was based on the idea that trying to control the trade in drugs was itself evil. I want to hold on to that word evil. We'll come back to that when we return to the actual United Nations legislation. But again, a couple other commissions as well. The Indian Hemp Commission claimed, ideas around cannabis causing mental illness greatly exaggerated. The Royal Commission on Opium, no evidence of moral or physical degradation with the use of opium. So at the turn of the 20th century, a very different idea of drugs as we've come to find in the 20th and 21st. And the trade in drugs, as I mentioned, being incredibly lucrative for colonial corporations, many of whom, like I mentioned, are now mainstream kind of institutions of global investment capitalism. The P&O Shipping Company got its start in the Opium Wars, which is now P&O Ferries. We see them everywhere. Jardine Matheson, which is now a Fortune 500 company, was founded by perhaps the two most successful, you know, opium smugglers and drug dealers in history, William Jardine and James Matheson, who were former East India Company employers who became privateers and started facilitating the trade of opium. And, one of the largest banks in the world, HSBC, started off with the Hong Kong, Shanghai, and banking corporations, all of them embedded in colonial trade. And the same happens when we think about cannabis in the West Indies. Similar happens when we think about the Dutch cultivation of coca in what's now modern day Indonesia, in Java. What we now call drugs were tradable, lucrative, psychoactive commodities, same as coffee, same as sugar, same as rum, same as tobacco, to a larger or lesser extent. So how does that change so drastically in the 20th century? So to many people, the 20th century project of international legal prohibition of drugs and the war that facilitated is described as the American experiment. So in a lot of ways, this is really America's first entry into the international legislative arena. Obviously prior to that, America still kind of constituting itself as a nation, but with the turn of the 20th century, following the conclusion of the Spanish-American War in 1898, America inherits, what it wouldn't call an empire, protectorate. Everyone who read How to Hide an Empire knows this story quite well. As part of the Treaty of Paris, Cuba, Guam, but most significantly for our story, the Philippines become American territory. And with the Philippines, America inherits, what it might consider to be a native opium problem. And through this, the kind of manifest destiny conceptualization of making Americans everywhere, there starts to be a tension between the kind of religious drive of Americanization that underpinned the protectorates and the use of opium by the native populations. And so a gentleman called Charles Henry Brent, who is the first bishop of the Philippines, starts to say that the use of opium is stopping this ability to make the locals into Americans. And he convinces one of the fathers of American international law. So this goes, one of the founders of the American Society for International Law, the American Journal for International Law, L.E.I. Root, along with his great collaborator, James Brown Scott. These gentlemen are at the very heart of the emergence of international law controlling drugs. Charles Henry Brent convinces them that opium use is a block on the making of Americans, and they're able to pressure President Roosevelt to establish a committee to investigate the opium problem, which then quickly recognizes that an opium problem is an international problem. America can't stop the trade of opium in the Philippines without getting the British to deal with what they're doing over, in British India, or, the French and, the French East Indies. And so they found the 1909 Shanghai Opium Commission. This is the first meeting of global powers in order to try and pass some sort of control on the trade of drugs, to differentiate these commodities from other commodities. That starts in 1909. Like I mentioned, this is very much the kind of first action that the US takes in the arena of international law right at the turn of the 20th century. Of course, the story can't be spoken about without recognizing the internal racial tensions that were driving the control of drugs within the United States of America itself. And so one of Charles Henry Brent's great collaborators was a gentleman called Hamilton Wright, who was like the medical expert around this early control of drugs. And, his report on the International Opium Commission to Congress in 1910, talks about how, cocaine is driving the Black populations of the South to engage in the crime of rape. There's a New York Times article, which is still available for anybody who wants to, look at this up, because hopefully New York Times helpfully archive all their articles. This is a 1914 article named Negro Cocaine Fiends Are a Southern Menace. And it's a story about, Black people in the South who are taking cocaine and not just committing crimes, but are like almost impervious to bullets. It's a story of this guy robbing a place. He's being shot by the police officer, and because of his use of cocaine, the bullets are kind of bouncing off him basically. And it sounds ridiculous and it sounds farcical, but then I think, to briefly fast forward into the 21st century, when we look at some of the justifications that have been placed upon the police violence upon Black bodies in the last decade or so, we can see echoes of that same story. With Michael Brown, we heard these stories around, well, he was high on cannabis, I mean, he was out of control. What could the police have done? They had to react. Same again with George Floyd. Well, we tested his toxicology report. He had, amphetamines, or he had pharmaceuticals in his blood. He was out of control. What could the police have done? They had to react that dramatically. And so that history continues to bleed into a lot of the modern day discussions around racial violence. But I digress. I just mention these because it's important to recognize how religion and race underwrote the construction of international laws on drugs in their early years. When we think about the international drug control conventions now, we might think of them as kind of being, scientific and objective and being drafted by people who were very dispassionate about the harms of drugs, and that's why they scheduled what could and couldn't be controlled. But the very first um, international meeting for the control of a drug was chaired by an Episcopal bishop, not by a diplomat or a juridical figure. It was chaired by a person who's been driven by faith and by a kind of evangelical mission. And the medical expert is somebody who's telling Congress that the reason we should ban cocaine is it makes Black people more likely to rape. And so this is the history of international laws on drugs. So following the 1999 Opium Commission, we start to get the first set of international drug controls being passed in law. And it starts, with the 1912 Hague International Opium Convention, which required anyone who signed the Treaty of Versailles to become a member of. And so this was America leveraging its newfound international muscle to bring the former colonial powers, into this discussion because, they don't want to give up their colonial drug monopolies. They're making a lot of money trading opium. But America starts to place the pressure on. Obviously, America doesn't join the League of Nations, and so we get a set of conventions passed through the League, but without any teeth and without much enforcement or compliance. And so, from the Convention of 25 to the 36th Convention for Suppressing Illicit Dangerous Drugs, we get some laws, international laws against drugs, but none of them really change the operations of the big international drug, dealers, if you want to use that word, which at that time were the colonial empires, Britain, France, the Dutch, etc., etc. But this all changes with the establishment of the United Nations, America really seizing its role as the hegemonic power in international law and making this kind of initial motivating issue of control of drugs one of its central demands of the new United Nations. The Second Convention on Narcotic Drugs 61 is a bit misleading because it actually began its drafting process in 48. It was one of the first things that the UN decided it was going to focus on. It just takes 13 years because, like I said, the other big colonial powers don't want to lose their drug profit lines. And so that negotiation takes some time, but eventually 61, the Civil Convention is passed, ratified, and the era of the war on drugs really begins from here. One thing I want to quickly point you to, just to kind of show this legacy of kind of theology that continues to inform our relationships to drugs on an international level, is the preamble of the Single Convention, which is the only UN treaty which contains a reference to the idea of evil when talking about what it's being and what it's passing its laws against. Um, and remember what we said about John Stuart Mill just a century earlier. John Stuart Mill, this idea of what was evil then was prohibiting drugs because that showed you didn't understand liberal free trade. It showed you didn't understand the kind of, the magic of the free market, the way the invisible hand facilitates profiteering, and you wanted to try and control and restrict people's individual liberty due to your own. In Stuart Mill's case, he would frame it in quite civilizational terms, the idea that, these backward Chinese people don't understand the free liberal trade of drugs and they're passing that and that's evil. And then you fast forward a century later, and now the trade of drugs is the fact that's the thing that's evil because of this religious inheritance of the prohibitionist movement. And a number of other legal treaties, do not mention the word evil. The treaty for apartheid, you can word search it, there's no mention of evil in apartheid. The treaty against nuclear weapons, no mention of evil in nuclear weapons. The treaty against, suppression of slavery, no mention of evil. Even the Convention Against Genocide, when directly referencing the actions of the Second World War, does not describe or place the issue that it's legislating over within the arena of the word evil. This only happens in the Drugs Convention. The work of Rick Lyons, one of the legal scholars, fantastic on this. I'd recommend people to check this out. And so, with the Single Convention on Narcotic Drugs, we get a bunch of UN treaties that are passed in pretty quick succession. The Psychotropic Convention in 71 that expands into psychedelics, and then the 88 Convention, which really gives the kind of military power behind the war on drugs. And it's around the same time that now successive US presidents from across the political divide start using this language of the war on drugs. Reagan talks about we're going to win the war on drugs. Bush talks about the war on drugs will be won neighborhood by neighborhood, child by child. Here we're talking about that kind of guerrilla warfare of that changing nature of drugs, of war, sorry, that I think we start to see, emerge itself in particularly the war on terror. This idea that everyone is a suspect, everyone is in this perpetual war. This really starts to become amplified with the war on drugs. Through this idea that therefore we'll be able to control and limit the spread of these substances and use of these substances. Just checking my time a second. But of course, I don't think I'm speaking out of turn where people might consider that this 60-year multi-billion-dollar endeavor to try and control the supply of drugs has not been successful. Drugs seem still to be around, last time I checked. And what has been the consequences then if it hasn't led to, by the UN's own statistics, a reduction in the use of drugs, a reduction in the levels of drug deaths, the addiction to drugs, dangerous diseases that are being passed through drug use. What has been the impact of the war on drugs if it hasn't controlled for any of those? Well, it's been its impact upon people, and this is the war element about it. The war on drugs. I think people should always think about it as a war on specific people, specific bodies, and race is again a huge factor in that. Unsurprisingly, when we think of those earlier comments from Hamilton Wright, we can see how that's brought itself to fruition at the end of the 20th century. We know in the USA, nearly 40% of those incarcerated in state or federal prison are for drug violations. And we know, from the work of someone like a Michelle Alexander on the new Jim Crow, the huge swathes of Black population that represent that statistic. But as I said, this wasn't just the USA, this is in the UK where, Black people are 9 times more likely to be stopped and searched for drugs than white people. In Brazil, again, 75% of homicide victims linked to the war on drugs are Afro-Brazilians. You see that devastation upon not just Black bodies, but indigenous land American bodies, migrant bodies, all these places suffering the heavy weight of the failed war on drugs. So I'll get through this quickly. But this is something that's now changing and changing relatively fast, particularly in relationship to cannabis. And so we know that the 20th century is starting to see a wave of cannabis legalization across the USA, but also, Alaska, Oregon, California, New York, and then we also know nation states, Uruguay, Canada, Germany, the Czech Republic, are all passing cannabis legislation, making it once again the kind of tradable legal commodity that it was in that earlier instantiation of 19th century European imperialism. But what if this is a war that's ending? How do we make sure that it's ending equitably? And how do we make sure that the harms of the war are being addressed at both an international and a domestic level? Because this is going to be a lucrative, very lucrative transition. According to Bloomberg, the global cannabis market is likely to be worth $91.5 billion by 2028. This is the legal cannabis market. And we know this is attracting, not just new cannabis companies that are emerging that are very lucrative, but also other kind of juggernauts of global capitalism, from Uber to Amazon to the tobacco companies like Marlboro, are all launching and investing in cannabis subsidiaries. Um, and so are they going to be the big winners of the end of the war on drugs? That's something I want us to think about. And how is international law going to be able to respond to this? Initially, people are considering, do these domestic changes lead to breaches of UN international law? Because places like Colombia or Mexico would say that the USA used to be the bully of international drug laws. They used to be the one who would make it a condition of trade agreements, a condition of being able to get debt relief, that you sign up to particular types of counter narcotics policing programs. Those aerial fumigation raids that I was talking about tied into this mechanism of enforcement. But now the US has multiple states and potentially soon federally level legalizing one of the prohibited commodities that are scheduled in the international laws on drugs. And so, you know, how does that respond? Does this contravene the provisions of the Drug Control Convention? That needs to be wrestled with. Different countries are coming with different responses. But it seems that these other institutions, particularly the International Narcotics Control Board, which is the UN kind of organ for policing the war on drugs, is starting to soften and recognize that this might be a transition that means we enter into a new era. I've got a 2023 quote there from the president who says that the expanding cannabis industry is marketing cannabis related products to appeal to young people, and this is a cause of concern as to the harms associated with this are being played down. But whilst that's oppositional, it still kind of recognizes that this seems like this is a problem with the future. It's talking about these harms are being played down, not this is a breach of international law and must be crushed. The US should be, and Canada and Germany, who are the legal partners, should be expelled from international law. As a result, that is not the response that we are seeing. And so finally, what I wanted to conclude with was asking what is going to be the role of international law. Oh, sorry, going too far. What's going to be the role of international law in facilitating this transition, and how can it be used or positively or negatively to facilitate what I would call reparative justice in the end of the war on drugs, particularly when we think about those harms that have been mentioned over the course of this presentation. Now is, the governance of drugs going to move from the UN control treaties to the WTO? Therefore, do we need to think about bilateral and free trade agreements? Do we think about intellectual property over the course of this international legal architecture? What happens to the the cannabis farmer in Mexico or Morocco or Jamaica when these large North American-based pharmaceutical companies start registering particular strains of cannabis as intellectual property, where they're only able to cultivate and able to sell legally? What happens to those traditional cultivators when they're blocked out of the market by the law? You know, what other vehicles for reparative justice could we mention? Should there be licenses, preferential licenses giving out to the people who suffered the harms in the war on drugs, who were arrested, who were displaced, who were, financially punished for trading something that's now a highly profitable commodity again? Should they be the first in line to get licenses to open up dispensaries or cultivation farms with the legal stamp? These are things that I think are questions for future international law scholars and students to think about, because this is going to be part of the terrain of international law in the 21st century. And if we think about ending war and how can the UN bodies be used to try and bring war to an end, not only to an end, but to an end equitably, I think these are some of the questions that we need to sit with and wrestle with. So I think that's my time that I've exceeded. So I'll stop there for now, but so I'll stop sharing. Brilliant. And I look forward to being in discussion, with some of my colleagues, particularly on the environmental elements, and also to any questions or any thoughts that any of the participants might have. So thank you.
Thank you so much, Kojo, for that great presentation and putting the war on drugs into an international legal framework, which is something that I suspect none of us, if any, have really thought about. So thank you for that. Our next presenter is Nadia Ahmad. Nadia?
Thank you so much, Marjorie. Thank you also, Kojo, for giving me the time to connect. And I think this is a really important topic that we're having about how international rulemaking is happening and what the changes are. And I think when we're looking at these changes as they are happening, we can also see like how these changes can happen, and they're not going to always happen as clearly and as easily as we would like for them to happen. And so what I have, for example, seen is that when these changes are happening, that the change it's a little bit different than how we may think that the change is going to happen. And so that's really what I wanted to focus on, is how we can also take it upon ourselves to be change makers. And this is not something that we not just specifically look at, we're looking at the law from an abstract lens, but how we can also be a part of the process, and how you can really start wherever you are in this process. And so I'm going to be speaking about international organizations, primarily speaking about the International Renewable Energy Agency, along with the International Court of Justice, along with the Court of Public Opinion, which is a very important court to also consider, along with the role of citizen journalism, along with civic education. So when we looked at South Africa's ICJ case, South Africa had filed a complaint at the International Court of Justice. It accused Israel of violating Palestinians' rights under the Apartheid Convention. There was also complaints that were filed against the Israeli president, as well as allegations of war crimes and crimes against humanity. There was a development, as well as other states also joining in this case, and this is something that is happening and ongoing right now with hearings earlier. We're also looking at the composition of the judges, which had also changed over on February 7th. So there is an update as well to the judges that are serving on the International Court of Justice. And so how this process happens in terms of how someone comes to the bench here is also something to consider in terms of what are all the different factors, because it's not always clear in terms of, what the law is and how it's going to be applied, because there's a certain level of subjectivity that also gets deployed. And what I also was a cause of concern to me was that a number of Arab states did not join South Africa's case against Israel in the International Court of Justice initially. And so what are some of the factors that led to that happening? And also, what are we seeing in terms of the variations between the International Court of Justice and the International Criminal Court?
Nadia, could you please slow down just a bit for the interpreters, please?
Yes, I can do that. Sorry about that.
That's okay.
And when we look at the United Nations member states, it includes 19 Arab states who are parties to the Genocide Convention. And they also have a right to file cases against any state at the ICJ South Africa's case documents. And they can also cite an obligation to uphold the Genocide Convention. But what we see as problematic, at least from my perspective, is that there is a level of inaction from the Arab states, and that they could have used their party status to actually file similar cases against Israel in the ICJ, and why it was really left to South Africa. So there's some maneuvering as well in terms of who's going to file the case, who's going to lead the charge for the case. But the fact that it has been left to other non-Arab states to pursue this case is something that is also very telling. And when we look at it from the U.S. Perspective, the U.S. Government's perspective is that there are not really any democracies in the Middle East, North Africa region aside from Israel. And specifically, if we're looking at the U.S. Senate Foreign Relations Committee and focusing on the Democratic members, only 2 of them have called for a ceasefire. And looking at these members of Congress, it's really astounding to see the level of hypocrisy relating to human rights interpretations and what they are going to consider a violation of human rights. And what we are seeing is that there is just a complete carte blanche that has been given to Israel to do as it pleases. And the Netanyahu government has had no calls for accountability from the United States, aside from very superficial levels of lip service. One of the things that I had worked with the group as well, including those from the American Muslim Democratic Caucus of Florida, in Texas, as well as at the national level, along with progressive groups, is to put together a ceasefire solidarity statement. This document had been prepared essentially to get a sign-on for a ceasefire. And the idea behind it was that to put anything in the document to make sure that there would be a sign-on for a ceasefire. So we tried to make it as equitable as possible, but also to put forward the concerns about the violations of international law. From this document, we were able to get over 100 signatories to it from various leaders within the Democratic Party, but we still are looking at February 22nd, and there's still no actual ceasefire that has happened. There has been a pause that occurred for a few days, but right now we're still looking at an ongoing genocide that is happening in Israel, in Palestine. And when we look at the broader body of international organizations that exist, they have a wide range of expertise, as well as of tasks that they're able to respond to. We have seen really the International Red Cross, the International Red Crescent, as well as UNRWA that have been stepping up to provide aid and humanitarian assistance. But there's also charges of ecocide as well as environmental violations that are occurring as a result of white phosphorus and other types of environmental degradation. And another thing that I'll get to closer on towards the later part of my talk is the impact of the bombing and the missile strikes and how it impacts the civilian population, but also the environmental impact that it has. And then the next thing that I wanted to turn to is the IRENA statute. The IRENA statute is known as the International Renewable Energy Agency. And this agency is an architect is the brainchild of Global South architects who are looking to see how to create a renewable energy agency. The rise of IRENA has been quite astounding, and it's seeking to create a way to have decentralization of energy access for poor, rural, and developing areas, and also to allow for price stability to exist. The idea behind IRENA is that without having electricity, there cannot be development. And without development, it's really hard to be able to encourage and protect human rights. And so IRENA really pushes for as an international organization for both cooperation and collaboration. The IRENA headquarters, as it was constructed, was quite an architectural phenomenon in terms of that it was a net zero building that had been constructed in Abu Dhabi, where the IRENA intergovernmental organization has been housed. It's really trying to use state-of-the-art technology for being able to limit electricity use and encourage energy efficiency. IRENA also developed the Global Atlas, which is something that you can actually download on your iPad or even access from your computer. And what the Global Atlas does, it provides for energy siting. And this process actually works to democratize energy production and also to allow for improvements with energy siting so that anyone is going to be able to check and see what type of renewable energy is going to be available in a particular spot. And part of the development of the International Renewable Energy Agency is also the reasons for being able to calibrate specific finance mechanisms and also work within the international rule-based system. And in this case, it involves the Energy Charter Treaty, which was developed as a result following the fall of the Soviet Union by former Soviet states to be able to protect various energy investments. And what we have seen is that the transnational energy law regimes have really expanded all over the world, but they're also being done in response to various climate change adaptation measures. But there is some levels of dissonance that occurs between climate change efforts, as well as being able to provide energy access. So you have on one side a desire for clean energy, and on the other side, you have a desire for development. And so there's a butting of the heads that happens as a result of that. Many have complained in a very valid way that much of the climate change adaptation has become like a green energy finance bonanza and has not really improved equity for energy in the ways that it had originally been envisioned. And one of the reasons for that is really the behind the scenes work that happens with OPEC in relation to renewable energy development, is that OPEC likes to keep the time horizon for fossil fuels as long as possible. But the reason to keep using fossil fuels is problematic on a number of levels, and that it leads to increasing levels of conflict because of natural resource scarcity and also for a warming planet. OPEC, though, was formed in 1960 with 14 different member states. It was also considered by some to be a type of really innovative labor organization or natural resource union for being able to provide for natural resource sovereignty. At the same time, though, it has become very powerful, and there has been concerns about how OPEC may be over-influencing the energy market. OPEC also has its own concerns relating to climate change, food insecurity, labor disruptions, terrorism, natural disasters, as well as the concerns about peak oil. And when we turn to the issues of climate equity, and this was also present in Kojo's talk as well about what the interconnections are. And so here we're seeing how frontline communities are going to be impacted by a number of different factors, including health, wellness, economic issues, as well as migration and race, and that we're going to see an increased frequency of extreme weather events as well as extreme storms. Those who will be most impacted by climate change will be small island developing countries, but we're also starting to see more aggravation of different types of climate conflicts that are occurring as well. For example, one of the precipitating factors for the Arab Spring was the drought and the concerns around food security. And if we look at it from a larger perspective, we're looking at it from the systems dynamic perspective. And the systems dynamic provides a way to see the interconnection that exists between the Paris Agreement, as well as the Energy Charter Treaty, and what can be done to create more resilient energy systems. When IRENA had been developed, it really wasn't a coincidence that the preparatory meetings of IRENA followed the global financial crisis of 2008, which precipitated the Arab Spring. So there was a number of economic factors. It wasn't as if there was like a desire or wellness to improve the environment. All of a sudden, there were specific economic factors that led up to it. And in terms of looking at how these theories are going to be working together, well, one of the things I'll mention is that this idea of resilience can really be used as a way to overcome adversity from natural disasters to political and economic upheaval, and that there's a sense that even though there is some discontent and upheaval within the system, it can be overcome. At the same time, there has to be a move away from looking primarily at Western legal tools for renewable energy law and governance, and also seeing that there are other possibilities that exist within indigenous systems as well as third world legal modalities as well. And by looking at that, we can see really the broader contours that exist relating to complexity theory and how it can impact systems as well as organizations and how they function. And so how this impacts the energy governance space is that it creates a broader way and a path forward to change. So, for example, evolutionary explanations relying on a historical discussion of human choices fail to convey an essential characteristic of the process. Law can only move in one direction along its path of change. And this forward movement of the law is characteristic of the concept of resiliency. And so that's why it's really important for us to see that it is possible to bring about change, but we have to understand the system and how it works to be able to deconstruct and dismantle the systems. The Energy Charter Treaty essentially was considered to be the one treaty to rule them all, and it minimized the effective investor-host country dispute resolution process. So in effect, what it actually did is it limited climate action because it was meant to protect investor countries who were trying to do fossil fuel development. And it pretty much didn't attract very much attention and remained largely unknown. I've been tracking it since at least 2016. And so there was a really exciting moment where now that there was problems where I was looking on my research about fixing a couple provisions in the Energy Charter Treaty to make it more equitable and balanced. There's actually now a number of countries, including the bloc even of the European Union, who are considering just walking away from the Energy Charter Treaty. And so that's really like quite revolutionary that they have an international system and they want to be able to walk away from it because it's in dissonance with the Paris Agreement, and that to be able to comply with the Paris Agreement would not allow for the Energy Charter Treaty to move forward as it does. The U.S. leadership on climate change was very important to achieve the Paris Agreement. And going forward, U.S. leadership would also be crucial in other types of climate, environmental, and energy efforts. But it's really important for the U.S. to also prioritize specific human rights. Law professor Uma Utka has observed that this context of federal policy reversal creates an environment in which companies counterposing renewable energy goals stand out. So, for example, in November 2016, the United States issued a document called the U.S. Mid-Century Strategy for Decarbonization. And also it set about to try to have low-emission economic systems that would be put in place to reduce climate change. So this was not only an environmental imperative, but also an economic one. IRENA has really been developing and growing over the years, and has actually grown quite rapidly. But we're still seeing that the actual outcomes of IRENA and from the Paris Agreement are still slow to be able to develop. And so some of the takeaways is that there is a financial crises that are happening. The banks have also sought to invest in specific types of renewable energy efforts, but still there is still a lot of there are still a lot of local efforts and national efforts that have not really been able to keep pace with what is needed to really bring about a system level change. And so what I wanted to next turn to is how lawyers can also serve as media masters, and how they have to account or discount respectability politics, also to take on the role of citizen journalists, and also empower activists to also take on this role of recording and reporting what is happening as a result of developments within the law, and seeing that there are politics of change and how to really understand them to disrupt them, and seeing how social media can also be leveraged to have this type of change. And so for me, and this is also a case that Marjorie had considered. I remember watching this case when I was in high school and being very intrigued by it. It had like all the elements of a very like very saucy story in terms of that you have a double homicide, you have like a car chase involving a Bronco. There's a whole flurry of lawyers that are involved with the O.J. Simpson case. And this really changed the dynamic of the way the law was seen in the United States in ways that is still playing out. And so I wanted to go through a few different examples from people that I know or I've kind of seen in the public space as well, and seen how they've really been able to develop the media skills to be more effective in the strategy and rulemaking efforts, as well as policy work that they are doing to bring about different types of change. And one of the reasons why there was concern around the O.J. Simpson case was there a sense that there was actually the Rodney King riots would play out, and the Rodney King case involved an African-American male who was beat by officers, and it was captured on video. And so that itself, the capturing of the video, was a type of citizen journalism, that they were able to capture it and then record it and otherwise bring to light something that would not have been visible. And so then you have the development of the dream team of lawyers. There is also this whole army looking at jury consulting and media spin. And it's also quite remarkable that even, for example, my grandmother, who didn't speak English, would watch the trial like every day, and then she would go on the weekends when she would visit her other friends and talk about it, and did you see what Marcia Clark did? Did you see what the judge was doing? Like, it was really it's kind of like very much like a soap opera in terms of how the case played out. So there's a definite narrative around it. Another person to consider is Chris Salamone. He developed Lead America, which is part of a broader industry of $10 billion industry of student camps and trip markets. And so he has really been working to develop a name for himself and has been quite successful in it, and looking at the space of media, sports, education, and business, and showing how to bridge the divide between law and businesses, and also educating students as well as a part of the process. Kendall Kofi is a former U.S. state attorney, and he had written a book called Spinning the Law, Trying Cases in the Court of Public Opinion. This is also a really important book to consider, because it has quite a bit of insights into how what is happening behind the scenes for cases, like how to get from one point to the next. Another major media figure as well as a lawyer is Ben Crump, who has really been instrumental in terms of making police brutality unsustainable as a financial model. He's also been very effective at developing press conferences and gaining media attention for specific causes that he works at. He had also been able to bring forward cases at the United Nations following the shooting death of Trayvon Martin in 2014 in Sanford, Florida. Henry Latimer was also someone who was considered a quite extraordinary legal figure, where he worked to develop like a new idea of diversity and really inclusiveness within the Florida bar. I was a Virgil Hawkins Fellow, and even after the U.S. had decided the case to end segregation in public schools, the University of Florida, my law school, did not allow for African Americans to attend the law school. They had to go through a certain other processes for that to happen. And so Henry Latimer has really worked to bridge some of that divide, and his work is still evident to this day. Another person to consider is Jose Baez, who has really developed a name for himself as in the criminal law area for developing specific types of media strategy. When he worked on the Casey Anthony murder trial, which some of you may be familiar with, he had essentially really kind of bet it all on this one case. And then since then, he's really been more effective in terms of developing and responding to media strategy. Dennis Salvaggio is a local Orlando attorney. He was effective because he was both worked on radio as well as in criminal law. He also was considered to he was known as the Orlando Magic Fat Guy, because he would run around the Orlando Magic arena getting people excited about the game and to cheer on the team. Another attorney to consider is Ariva Martin. She has also developed quite an extensive repertoire in terms of how to use media to leverage business as well as branding. And she also has a talk show as well, and is based in Southern California. And so as I get to that, I wanted to look at how respectability politics also plays into this place. So, for example, I come from the environmental justice space, and one of the key ideas around environmental justice is that we speak for ourselves and that we should not really pay heed to respectability politics, because environmental justice and frontline communities have suffered for so long, and for them to really do the tone policing to be effective and to really show the concerns can be problematic, even though it may and that those who are impacted by it have to be able to speak as they are discussed. And so, for example, if we look at the ICJ case, it was really interesting to me, for example, that all of the hearings they were in English, even though they were translated into other countries, into other languages. So what exactly does justice sound like? Does justice sound like English, or does justice not exist in other languages, or does it only be able to exist if it's brought forward in English? And so the early iterations of environmental justice happened in Warren County, North Carolina, where you could see that it was part of a multi-faith as well as multiracial coalition that looked at environmental justice. These protesters really put their bodies on the line. They had laid down in front of the dump trucks that were going to pollute their communities. And when historical archives had looked at the arrest records of those who had been detained as following the protest, it was a quite extensive list of those who were arrested, and showing the power of direct action, building large coalitions. Another case that has kind of captured the imagination is the Flint water crisis, where there has been a settlement, but then looking to see, what is water infrastructure and how is it going to be impacted. What I see as problematic, for example, right now, is the Biden administration has been pushing forward that it's allowed for funding for clean water infrastructure in the United States, and that there's this mechanism that's put in place so that everyone will have clean water within the next 9 years or so. But the problem with that, for example, is that when the United States provides military aid to countries like Israel, it allows for specific types of destruction of water infrastructure. It shows kind of like how there's two different sides of environmental justice. So you have those who are the third world countries, as well as those who are minorities within the United States, who don't have the same access to clean water infrastructure. Another concern has been the indigenous campaigns against the Dakota Access Pipeline. So not only are there concerns about clean water, but also the contamination and pollution that occurs from fossil fuel pipelines that can lead to specific leaks. One of the protests that had happened around the Line 3 pipeline is that the protesters used specific types of codes when they were doing the protest, and so they wouldn't actually disclose what the location was. They would use code words like marmalade or peanut butter to hide the location of where they would actually be doing their specific type of action. And so in terms of looking at the frameworks for environmental justice, we see a model for distributive justice, procedural justice, which would happen through the court system, as well as corrective justice, which could happen through administrative agencies, and social justice. All of these efforts have to really work together to provide a specific type of framework for environmental justice. Ben Crump had also looked to see how, in terms of filing personal injury cases, about those who may be impacted by specific types of products and how they may increase cancer risk. Talcum powder was one of those, and what was a cause of concern is also how it was being marketed to Black women, and how they had really been targeted to use this particular type of product, which had very dangerous health impacts. Another major case to look at around environmental justice, which is in the US, is the Village of Arlington Heights versus Metropolitan Housing Development. This lawsuit is a matter of kind of building precedent, but also seeing that there really wasn't any other reason aside from race to show that there had been some level of official action that had led to discrimination. And so really building the case is what is important to do, but also seeing that the law can also serve as an impediment to justice as well. And one of these cases is the Sea Clamors case of 1981. And so this essentially limits plaintiffs' rights. It also provides for additional mechanisms for property rights under the Due Process Clause, and it creates a number of procedural and legal barriers to be able to try specific environmental claims. There has also been concerns about the community demographics that are impacted, the concerns from the communities themselves, and whether the EPA has jurisdictions. So these are also tussles that are happening as well. So not only is there federal concerns, there's state level, county level, and local concerns. So all of those various dynamics have to be taken into account. And so I wanted to share with you one example of the Trinchera Ranch case to just show you and illustrate to you how a battle for an energy easement will look like. So this is Louis Bacon, who's a hedge fund manager in New York. He bought this parcel of property from like the Forbes family. And as soon as he bought the property, it was, he found out that that Tri-State Generation and Transmission Association, Xcel Energy, had actually acquired an easement, but they had gotten a permit to be able to build a massive transmission line across his property. The property purchase at the time was the largest residential purchase in US history. And the area that was impacted would essentially impact his aesthetic view shed. Like he didn't like the fact that this power line would be constructed and then mess up the view that he had of this very pristine area. And so even though that would be able to impact quite a number of individuals who would be able to receive electricity from this power lines, he was able to really work behind the scenes, both through his resources to have the litigation team, as well as a media campaign as well against it. And so if you think about who would win, in most cases, the utility companies would win. But in this case, Louis Bacon was able to be successful. And not only was he successful, in the case, he had spent about $10 million between the media strategy and in the courtroom. He also ended up getting a conservation easement of $10 million. So essentially, he was able to recover the funds that he had spent to preserve the property. And so these ideas kind of go towards, what actually, what counts as property, and that there's this sense that property is the material foundation for creating and maintaining the proper social order, the private basis for the public good, as well as seeing, how people are going to be specifically impacted. And this is idea that flows from Aristotelian thought. Another example here is the Chokecherry and Sierra Madre wind project, and this would be the largest wind farm outside of China when it's constructed, and this is in Wyoming, in Carbon County, Wyoming. This area has the highest velocity of wind, and it's just very good area for wind. And so the area here to construct the easement went through quite an extensive process, and the goal was to actually take the energy that was generated in Wyoming and connect it to the California grid, because California had a lot of market incentives to have clean energy production. The concern was, though, that the transmission line would be crossing over several states, and those states would not be receiving energy. So that was another thing to also consider. And so I had recently attended the COP meeting, which is with Chinti Vitanje, who is at Pace Law School, and we were the American Bar Association's observers at the COP meeting. And so when we attended the COP meeting, we also saw how a lot of these systems were developing. And it also showed like the possibility of change and how things were going to be developing. And one of the groups, for example, that I have seen doing a lot of work is a group called Climate Defiance, which has really emerged to try to disrupt events and to shut them down. They've been able to be successful because they developed a specific media strategy and social engagement strategy. This is similar to what has been done by Sunrise Movement earlier, which staged sit-ins in Nancy Pelosi's office calling for divestment from fossil fuels. Another resource is The Long Game by Dory Clark, who writes about how we have to be long-term thinkers in responding to these broader crises, and that we have to not just look at the 5 days or 6 days time horizon, but look at like 1 year, 2 years, 3 years, 5 years, what can be changed, and how can we achieve specific objectives that we seek. Another important resource is by Ozan Varal, who is a former law professor. He is also a rocket scientist who worked on the Mars mission, and he wrote a book called Think Like a Rocket Scientist. And that is also another very helpful book that I would recommend to think about, how to think outside the box to achieve change, or even to achieve specific goals. And so this brings me to my next point about citizen journalists, which means that, basically any of us who have any type of device, whether it's a cell phone or anything, we're able to take on this role of citizen journalists. And so that was really some of the impetus that led to the right to a healthy environment at the UN General Assembly, which I was really glad to be a part of as a part of a broader coalition of over 1,400 organizations. And I was able to take my kids with me as well to when we accepted the UN Human Rights Prize as a part of the coalition. And it showed me the power of being able to make change. And what I also saw, like I shared with you earlier, the members of the US Senate Foreign Relations Committee. And so for that process, we had basically targeted members of the US Senate Foreign Relations Committee to be able to get the US on board for this new resolution, because the US is not very much keen on having new environmental or new human rights regimes, but showing the US government during the Biden administration that this is something that they would potentially support if it was brought to Congress. Another thing is a project that I've been working on is on Black Lives Matter and Gen Z energy, and being able to channel it through my scholarship. And so right now I have a piece that I'm finalizing on military climate emissions to show that demilitarization is probably a more effective climate strategy, because it also frees up capital for climate adaptation. Currently, the United States spends over $1 trillion on defense and military expenditures, and parts of that could more effectively be reallocated towards climate efforts and towards environmental justice. Also looking at the politics of change is bringing on this idea that we're also going to be able to impact the change. In 1968, the DNC convention was held in Chicago. It was a complete disaster because of the level of anti-war activism that had happened. And as a result of the disaster that had happened in Chicago that year, the DNC was not very keen to have the DNC convention again there. But then it decided to do so for this year. And so one of the strategies that we have is how to become a delegate. And so you have to become like registered as a Democrat to satisfy specific eligibility requirements, participate in the primaries or the caucuses, fill out any necessary paperwork, or also be able to get support. So for me, I basically just asked my dad if he thought this would be a good idea. I usually just run things by him. And so he told me, yeah, I think this would be a good idea. Why don't you do it? So I didn't really know. And I first decided to do it because I was interested in it from an academic perspective to how the process works, but then I realized it wasn't that hard. And so I also had to kind of build up my own campaign to do that. And so I looked at some of the other cases that I had worked on earlier or been involved in different conferences and how to kind of think about, how am I going to leverage this type of experiences for this campaign. And I also looked at some of the environmental advocacy work that I had done earlier related to when I worked on a memorandum for our Children's Trust, which had filed, which has worked on atmospheric trust litigation, and also some petition work for Stephen Donziger, who had brought forward a lawsuit in Ecuador for Indigenous plaintiffs. So then after that, I started to develop a campaign working with different political organizations, including Progressive Democrats of America, along with Our Revolution. I also organized different types of phone banking events as a part of this process, and just to kind of speak about it. So I was actually successful in my campaign when I ran and filed. And so after the convention, I then ran to be a DNC member, and was also successful as a part of that process, and also helped to organize various events at the DNC convention in 2020, and hope to do so as well in 2024. And some of the events that I did involved phone banking to really get out the vote for the 2020 presidential primary. And one of the things, if you look at the slide on the bottom, is that the groups that are the coalition members are basically the groups that are the ones that are not really welcome to the table. So for example, I have the Chinese American Voting Alliance, the Vietnamese Americans for Biden, African Diaspora for Biden, the Democratic Party of Orange County, because California is also not the DNC is not a huge fan of California. And then, for example, Japanese Americans for Biden, Arab Americans for Biden. You get the point. Like the groups that are not as well received, we were able to kind of mobilize around those groups, and we had local events as well. And then when Build Back Better was brought forward, we organized a protest in front of our Congresswoman, who is a Democrat, and was not supporting it for various reasons. And then as we were doing this, we tried to also really include like part of the broader process, so not just in the state of Florida, but also in other states. For example, in Massachusetts, we did different type of work, as well as with Our Revolution, which was the political action committee for Bernie Sanders. And we worked, doing on different types of events for that. And then also we had worked on doing some of the policy work around the Breathe Act in 2021 to help to connect activists as well as lawmakers for that legislation. And then one of the issues and concerns is that how this is why, for example, when I showed like Arab states are not supporting the ICJ case, or not kind of supporting in a substantial way, is that there's really been a lot of deep state penetration in Muslim country organizations and Islamic institutions. And this is really done by design to really have influence over civil society, to do what it wants to have happen. And so Ronan Farrow, who is the son of Mia Farrow and Woody Allen, wrote a book called The End of Diplomacy and the Decline of American Influence, The War on Peace. And he really goes through kind of step by step during his time at the State Department and showing that that there's really more of a push towards war all of the time, and why the art of diplomacy has really declined. And this book is really spot on and goes through quite a bit of intricacies that I won't get into at this time. But I just wanted to also kind of point out as well that there are like specific initiatives that are put forward in place. For example, the U.S. Department of State and the Department of Defense have certain organizations that have really been supporting and are also kind of support a broader goal of preservation of the Abraham Accords. And so these are groups and organizations that are really kind of pushing a specific agenda going forward. And then there's also, for example, like organizations that have this particular bent, but there's also organizations even within the Muslim civic engagement space that also are considered to be more respected or more trusted by the DNC. And so I'd given a portion of this presentation to another group before, and they were kind of questioning, how can you list our organization as a DNC trusted organization? So even when I was putting together my slides, I wasn't sure how I could actually provide proof of that. But I finished my presentation at 10 p.m. on a Sunday night, and at 10:12 p.m., former senior advisor at the DNC, along with the head of one of these organizations, was texting me. And so I thought, wow, that's my proof, is that it takes me months to get people to respond. And then these people are on instantaneous communication with parts of the DNC. And so I think it's important to also see as well, there's this idea between a good and bad narrative among Muslims. And so I think we also see a maturation of Muslims in the political space. So for example, when President Biden had hosted, or the DNC had hosted its first campaign events of 2024. We worked to recruit protesters for the event. I think we recruited about 40 different protesters. Some of them were not let in to begin with. Some of them were removed, but it led to about 14 different interruptions at that particular event, and it had a cascading impact at future events as well. Another similar effort was Kibbutz Blinken, which is protesters who are outside of Blinken's house who have been protesting for going on over 3 weeks now. We also see some of this overlap that happens in the problematic spaces. So on one side, you have protesters who are developing or protesting, in support of Palestine in Michigan, because Michigan is considered a swing state and has a large Arab and Muslim population. And at the same time, you see officials from the Department of State and the Department of Defense who will show up and meet with local leaders, including the mayor of Dearborn, right afterwards. So, for example, Mayor Abdullah Hammoud had rebuffed efforts to meet with campaign officials as well as Biden officials. But then a week later, just this past week, he had met with Muslim members from the Department of Defense and the Department of State. And so it shows you some bit of the double-sidedness that is happening in this space, which is something to watch out for. So we have also developed specific platforms as well for being able to support ceasefire actions, which we have been working with Code Pink, Roots Actions, Our Revolution, and Progressive Democrats of America to build out a broader infrastructure for this type of work. We also prepared a letter through the Muslim Lawyers Group to have lawyers sign on to urge the Bar Association to fight censorship of pro-Palestinian voices. And actually, last night, my daughter asked me, she's 9 years old, she's like, Mom, what is censorship? Why exactly do people censor things? And so the idea of censorship is that you're really suppressing democracy as well. And especially for those who are advocating for peace and nonviolence, it's very antithetical to the very foundations upon which our democracy stands. So there's a number of different strategies that can be used. So whether it's protests and demonstrations, or petitions or letter or email campaigns. For example, we also worked with Code Pink to do the petition deliveries for the ICJ case. You can also be involved in awareness campaigns. You can try to build out celebrity and influencer engagement, as well as other work for symbolic gestures, including wearing bracelets or ribbons. There's also specific types of direct action. United We Dream had done a number of direct actions as well relating to immigrant rights. They had done an action last week as well in the Rotunda where at least 13 people had been arrested. And there's also a development of shareholder advocacy as well that can also exist. So these are some of the different strategies that are there, and I'm happy to answer any specific types of questions.
Thank you so much, Nadia, for your activism and great discussion of racism, the profit motive, and the military as impediments to environmental equity, and the role of the people as well as citizen journalists in the struggle for equal justice. Now we will turn to Dinorah, and please speak slowly for the interpreters. Thank you so much.
Thank you, Marjorie, and thank you for the invitation to the organizers. And it's a pleasure to share this space with the other panelists. Okay, next slide. The UN Charter is organized in chapters. The most important one is Chapter 11, with the Declaration regarding non-self-governing territories. Next. The UN system under the Charter, especially Article 73, there you see items A to E. The UN Charter includes also Articles 1, Item 2, and Article 55, which contains the principle of self-determination of peoples. Dependent territories are in Chapter 11, and Chapter 12 establish the trusteeship system. Nevertheless, the trusteeship council is in Charter 13, was a principal organ that supervised territories, but is now closed since November 1994. There are other mechanisms that I will explain later that you can use. Article 73 of the Charter is the recognition of the obligations by member states to accept this sacred trust, as they call it, and the obligations to promote the well-being of the inhabitants of the territory. Of the 74 non-self-governing territories, 8 became independent. From 1946 to 59, 21 discontinued the transmission of information, mostly because there were changes in the relationship. In other cases, the decision was unilaterally taken by the administrative power. Other metropolises either denied they had obligations under Article 73, like Spain and Portugal, or did not permit observation missions to the territory. That was the case of the UK, United Kingdom. Next, please. The mechanisms under the Charter, they include the Human Rights Council, which is the main expert organ that monitors implementation of human rights and supports all other mechanisms. The special rapporteurs, the special procedures of the Council include special rapporteurs, independent experts, and working groups. They have special mandate of reporting and advising in different topics and countries. They can make country visits and take individual communications and broader concerns. There are 46 thematic mandates. some of them dealing with transnational corporations, development, cultural rights, disabilities, environment, displacement, disposal of hazardous substances and toxics, etc. There are 14 country mandates, which include, for example, the Palestinian occupied territories since 1967. Universal Periodic Review is where member states undergo a peer review every 4.5 years to improve human rights situations, and also includes recommendations. Independent investigations are the International Commissions of Inquiry, Commissions on Human Rights, fact-finding missions, and other investigations in order to promote accountability and counter impunity. Next, please. The Article 73 lists the responsibilities of the administrating power for the territories that have not attained self-government. That is the case of Puerto Rico. To wit, respect and ensure the culture of the peoples, their political, economic, social, and educational advancement, and just treatment, develop their self-government, help promote development, and transmit information to the Secretary General. Next, please. After a year of military government, the U.S. Congress approved the Foraker Act in 1900 to establish a civil government. The legal framework as altered to fit procedural matters into the U.S. federal system, but the civilian body of law was left in place because it was similar to the property law doctrines of individualism under U.S. Anglo-Saxon law. Nevertheless, the tariff and taxation systems were imposed, which responded to U.S. government and its economic interest. U.S. tax law exerted economic dominance over its colonies. American Samoa, Guam, Northern Mariana Islands, U.S. Virgin Islands, and Puerto Rico since the beginning of the invasion until today, and are still under such impositions. Even after the Commonwealth status in Puerto Rico was established in 1952, Puerto Rico is still under the plenary powers of Congress. In 1953, the U.S. argued that since the island had attained self-government, the United Nations had to remove it from the list of territories under Article 73, Item E. Since then, until recent cases of Sanchez Valle and Franklin California Tax-Free Trust, determined by the U.S. Supreme Court, the people of Puerto Rico had the impression that there was an autonomous arrangement in place. After these cases, and after various presidential reports, the relationship has not changed. In the middle of the financial crisis that we have today, the island was left without any warranty that either politically or financially the island would have a bailout. Today, the argument about self-government has completely fallen apart. Since the insular cases, plenary powers of the U.S. Congress still apply. The imposition of the Promesa Statute is also proof of the colonial nature of the Commonwealth and places the island at the beginning of the 20th century with Foraker Organic Law of 1900. Next, please. On 1959, the General Assembly established a committee to study the guidelines for deciding transmission of information and for members to determine whether whether or not an obligation to transmit information existed under Article 73E. This committee issued a report and the General Assembly adopted Resolution 1541, Roman numeral 15, in 1960, where it established a legal obligation to transmit information about the territory, which is, and I quote, geographically separate and distinct ethnically and or culturally from the country administering it. End of quote. Additional elements regarding political, juridical, economical, historical, or other nature can be considered to support this obligation to transmit. In 1960, the General Assembly included in the agenda the Declaration on the Granting of the Independence to Colonial Countries and Peoples. In its sessions of November 28 and November 14, 1960, that was the session. 43 Afro and Asian states sponsored the draft declaration, which was adopted on December 14 of that year. And such declaration became Resolution 1514, Roman 15. Resolution 1514 proclaims that alien subjugation, domination, and exploitation is a denial of fundamental rights and is contrary to the Charter of the UN. Next, please. Other options to carry the task of the special committee are the receipt of written petitions and the hearing of petitioners. Shortly after Resolution 1514-15 was approved, the General Assembly approved Resolution 1654, Roman numeral 16, which created a special committee on the situation with regard to the implementation of the declaration to promote the decolonization, or Committee of the 24. The right to petition is a fundamental right. Thus, in 1951, the Fourth Committee of the General Assembly and the Decolonization Committee agreed to hear petitions. In the Decolonization Committee, Puerto Rico's individuals and NGOs have the opportunity to petition, and they do so annually. The special committee then can make recommendations based on the information provided by them. The UN Decolonization Committee has approved 41 resolutions and decisions on Puerto Rico already. In 1972 and 73, the Working Group on the Decolonization Committee issued a report on the procedure to implement Resolution 1514-15, but instead, an annual report by the Special Rapporteur has been issued. On June 2021, it approved a decision affirming the Latin American character of Puerto Rico, and I quote, which its residents have been able to maintain despite the actions of the colonial power, end of quote. Also, it expressed concern in the imposition of the control and economic influence by the US and the repression against activists. This committee has repeatedly stated that any mechanism or vote on a plebiscite must be free, not under duress or intimidation, and taken by well-informed voters, which is a problem we're in a colonial situation. This process is possible under the mandate of Resolution 1514-15, which also permits fact-finding missions and NGOs communications to the committee on the territory under observation. But how to implement 1514-15 and make the case to the General Assembly's Fourth Commission to examine the situation of Puerto Rico? This is a question attorney and expert on self-determination of Puerto Rico, Wilma Reverón Collazo, based in part on the opinions of Professor Mari Bras, urges to take the case to the International Court of Justice in an advisory opinion. Other options include to call on member states to express their concerns and examine the case of Puerto Rico, and hope that the majority of states will vote to include this case in the agenda, as she well mentions. On December 15, 2022, Puerto Rico Status Act was approved by U.S. Congress. For the first time, the U.S. recognized the role of as a colonizing force. The alternatives offered are between statehood and independence, excluding the actual Commonwealth alternative. The referendum planned for November 5, 2024, includes a free association option similar to the status of the Marshall Islands and Micronesia, and will be supposedly a binding referendum. The problem is how the aspirations of the colonized people are to be expressed, and the UN Charter does not provide for direct involvement of the UN, except for the examination information transmitted by the administering members. There are various alternatives in the case of the trust territories. The Trusteeship Council might provide periodic visits, hold general elections, and form a constituent assembly, which will draft the constitution, forming a representative government. Also, to ask the Secretary General to take action in consultation with the administering power and the special committee to ensure UN presence and supervision of the elections. Although the Trusteeship Council disappeared, these options are still available and are a good idea to implement. With respect to the options to elect representatives of the constitutional process, it can be through a referendum, plebiscite, constitutional assembly, or other mechanism. Next, please. During the late 1950s and 60s, independence was being fought and attained by African nations and elsewhere. When the countries that participated in the Tehran Conference approved Resolution 1514-15 of 1960, being the basic instrument for self-determination and independence, the U.S. submitted additional resolutions to counter Resolution 1514. It did so even though it abstained in the voting when Resolution 1514 was voted and approved. The United States later argued, dismissing the international law argument, that Resolution 748, Roman numeral 8, had already decided the issue of self-determination of Puerto Rico, and in any case, it was a domestic issue. Resolution 1541, Roman 15 of 1960 was proposed as an alternative, but only includes guidelines for solving the political question. Resolution 1541-15 cannot circumvent the responsibility imposed by the UN Charter in Article 73. Among these guidelines, there is annexation or integration, according to the wording of the such Resolution 1541, free association and independence. General Assembly Resolution 1541-15 was concerned with the forms of attaining full measure of self-government, but integration or even annexation cannot be a part of self-determination solution, at least in our case of Puerto Rico. Resolution 2625, Roman 25, provides for any other possibilities besides independence, association, or integration. And this resolution has been used by the Popular Democratic Party, which wants the the status quo, the Commonwealth. Integration should be on the basis of a complete equality as regards to the representation and effective participation at all levels in the executive, legislative, and juridical organs of government, and should come about only after integrating territory, the unintegrating territory, ascertain an advanced stage of self-government, and then advanced stage of self-government in quotes, in quotation marks, that Puerto Rico has never attained an advanced stage of self-government, especially at this moment under the Promesa statute imposed by the U.S. Congress. When an administrative power pretends to annex territories that are not independent or non-autonomous, whose population has a distinct culture, language, history, and origin, it means that those colonized peoples would have to renounce to their culture and to their identity. Some commentators have argued that the right to protect their own identity and to choose their own destiny is sufficient cause to activate the right of self-determination. Attorney Fermina Raiza Navas made the distinction between integration and annexation based on the advisory opinion of the International Court of Justice issued in 1970 and which deals with the Namibian case. Araiza made a comparison with the case of Puerto Rico. He wrote that the alternative favored by the stateholders want to integrate to the U.S. Nevertheless, since we are not the same peoples, we cannot be integrated to the U.S. Instead, if annexed, it would imply also the cultural disintegration and disappearance as a peoples that have a different international personality politically and culturally. The case of Namibia is illustrative because it deals with the steps that had to be taken in order to complete annexation. The ICJ's advisory opinion concluded that an annexation of one country with a different culture to the receptor country is not possible. Neither Puerto Rico nor the U.S. government have even started an education campaign so the people can inform themselves of the consequences of each option. Next slide, please. UN treaty-based system mechanism has each treaty has its own committee. The U.S. has ratified the Convention on Racism, the ICCPR, which is the Civil and Political Covenant, the Torture and the Genocide Conventions, but it's not. So it has had to defend itself by submitting a response report when an NGO submits a shadow report or a communication on a human rights violation. Next, please. In 2003, some NGOs decided to use the treaties ratified by the U.S., taking their petitions to the human rights system in UN Geneva. Representatives of NGOs like the American Association of Jurists and others presented the case of the death of David Sanes, also the cancer, the displacement, the environmental disaster caused by the U.S. Navy in the islands of Vieques and Culebra. Research done by the University of Puerto Rico found not only enriched uranium, but many other substances that are prohibited under environmental treaties. Other violations have been denounced, submitting written communications to the High Commissioner of Human Rights on Colonialism under the Civil and Political Convention. Economic hardship and also communications to the special rapporteurs on topics like vulture funds, right to development, etc., have also been used. Worker unions have used also the specialized agencies, like, for example, the International Labor Organization in Geneva. The US has ratified only a third of the human rights multilateral treaties that are important. For example, the Convention on Civil and Political Rights, as mentioned, the Convention Against Racism, the Torture Convention, and the Genocide Convention, among others, like Love the Sea Convention, but the 1858 one, not the 1958, not the 1982 one. The US does not recognize the individual petitions, in the UN or in the regional Inter-American system, but only recognizes the cases brought by other states. This is why the Nicaraguan case, Nicaragua versus US, was so important, and recently the South African case in favor of the Palestinian people at the International Court of Justice is also important. The US has, as an administrative power, has to comply with the UN Charter and also with the treaty obligations. For example, as I said, the ICCPR, especially with the Part 1, Article 1, Paragraph 3, that talks about self-determination. Treaties are the law of the land. So even domestically, the US is bound by its own decisions of ratifying those treaties. Also, the Vienna Convention on the Law of Treaties is an essential instrument for compliance. The Birkbeck case is illustrative of human rights violation that would amount to grave violations against humanity, affecting more than 9,000 people for more than 25 years of displacement, health, and environmental issues due to the toxic materials like depleted uranium and due to the live ammunition being fired almost every day by the military maneuvers of the US Navy and NATO. That was they are not going on right now with the live munitions, but they are exploding the mines that were found there. So all the toxic materials go into the air still. One of those projectiles killed a civil guard who was working in military grounds. This was a turning point for the Birkbeck struggle, since it prompted the majority of the population in the main island to support the people of Birkbeck through massive protest, civil disobedience, and arbitrary arrests. NGOs petitioned the High Commissioner on Human Rights, arguing grave violations of human rights under the Universal Declaration of Human Rights and treaties ratified by the US. Even if the US does not accept individual petitions, as I said before, it had to submit periodic reports. In the Durban conference, the term environmental racism was brought up and accepted. The US has used environmental racism on its own population by experimenting and sponsoring the activities done by multinationals in the border with Mexico, Puerto Rico, and indigenous peoples from Alaska and Hawaii, located in poor communities. Experimenting against the will of any human being is a violation of the International Covenant on Civil and Political Rights in its Article 7, besides other international instruments, and probably falls into the Genocide Convention too. The Genocide Convention was also ratified by the US and requires intention to destroy by inflicting damage, either physically or serious emotional harm, and deliberately to cause damage to a particular group. In Birkbeck, the time since the Viequenses suffered bombing, forced displacement because the U.S. Navy took their lands for security purposes, not having adequate medical care, there's no hospital in Vieques, and because of lack of information, the U.S. Navy did not want to offer information on the toxic materials that are deposited in the soil and waters of Vieques, the accidents that have occurred, etc., and the displacement. One can see the intention to configure genocide. This genocide convention does not have a committee to supervise, but cases are presented to the International Court of Justice directly. The state has to accept and consent to the jurisdiction of the court, something that the U.S. is unwilling to do also. Next slide, please. Next, please. Here we see the Vieques location. So it is pretty, you see in the middle the people that are settled in the middle, and that's the lower portion of the map. You have in each side to the west and to the east. The U.S. Navy was located there in 2003. So as you can see, the people were, the displacement was really obvious. And they suffered all the contaminants, all the toxics, being in the middle. Next, please. NGOs have a duty to inform themselves and keep petitioning in different fora, using not only the UN Charter, but also the treaty system, and always denouncing human rights violations. They have to keep sending communications to the Human Rights Council, its special procedures, and they should be aware of the dates when the country in question is up for the Universal Periodic Review and in situ investigations. NGOs must be ready to submit shadow reports, petitions, personal and written, and use all the procedures available. Individuals as well as NGOs can petition the UN Special Committee on Decolonization or use the committees on the treaty systems. Even though the US made a reservation when ratifying ICCPR by trying to undermine its obligations by saying that none of the international instruments are self-executing, such reservation might be against the object and purpose of the treaty. This can be an additional violation to the Vienna Convention on the Law of Treaties. Moreover, the Supremacy Clause of the U.S. Constitution and the Paquete Havana case, among others, are the law of the land, as I said, and are in conflict with such reservations. The Inter-American system is more flexible because it allows for individual petitions and NGO petitions representing communities. NGOs used the system for petitioning in 2017 on behalf of the communities that were abandoned during Hurricane Maria with good results. Even though the U.S. has rejected the Inter-American Court jurisdiction and has not ratified the American Convention on Human Rights, it has had to respond. Also, there was a case brought by the Shoshone tribe on the Inter-American Commission and Court, and they had also used the Racism Convention and all the American Declaration of Human Rights with very good results also. So thank you for your attention, and if you have any questions, I'll be happy to answer them. Thank you.
Thank you so much, Dinorah, for your excellent discussion of the history of the U.S. imposition of and maintenance of the colonial status of Puerto Rico, the violations of international law, and the use of UN mechanisms in the struggle for the self-determination of the people of Puerto Rico. We will now turn to our discussion portion of the program, and I want to begin by giving the faculty members an opportunity to respond to each other's presentations. We somehow lost Kojo Koram. I just sent him an email. Hopefully he will be back on. But Dinorah and Nadia, if you would like to make any comments about the presentations, then we can move on to the Q&A with the attendees. Thanks.
Yes. I have a comment for Nadia, or probably a question, I don't know. Well, might be a comment. In Puerto Rico, they destroyed the access to the electric system and water and other resources. So they can, I mean, they meaning the US and the government of Puerto Rico. So they can contract multinationals or other businesses that have, or they have interest in the government. This is so common in Puerto Rico. So I wonder if, for example, Luma Energy came after the destruction of and the bankruptcy of the island. Do you have any case that deals with that?
So what I saw, for example, after Hurricane Maria in 2017 in Puerto Rico, there seemed to be like some attempt at like having a renewable energy land rush in terms of trying to do like solar energy development. And one of those investors was Elon Musk. And he was essentially rejected from the people of the island, and there was just concerns about how much power and how much what would be the takeaways for, or what would have to be given in order to receive from him. And so I think this like give and take process, it's not a very fair process, and it seems to be more like a take and take process versus a give and take process. And I was actually in San Juan last summer, and the ABA also hosted a disaster law conference a couple weeks ago in Puerto Rico. And this has been an issue of concern, but I don't think anything's actually really been done substantively for it. It really seems like communities are left to fend for themselves. There's parts of Puerto Rico, as you know, that don't have power from when they lost it, years ago. And this is like, I think when, like, for example, when we have a hurricane in Florida, like we'll get the power back in 3 or 4 days. Whereas I remember I was teaching a class, energy law class, and one of my students, her father was in Puerto Rico. She didn't hear from him for about 2 weeks because there's no way for communication. And so being able to bring systems back online, not just like energy systems, but also communication systems, it has a really detrimental impact. And I think also another point that you touched upon is this idea of how like corporations are trying to take advantage of tax structures or lack of them in Puerto Rico. So how Puerto Rico is essentially serving as a tax haven for large corporations is another problem, and there really isn't accountability. And then I think an even greater problem is that there isn't representation in government. Like there's no ability for people from the island to be able to vote for the president. And so all of this kind of is kind of like a part of this idea of representation and democracy as well.
Right, thank you so much.
And I would also add to
that is also,
yeah, I would also add to Dinorah's presentation. I was really struck by this idea of the like I feel one thing that, or of many things that Puerto Rico is better at than the mainland US is being able to stand up for itself. So for example, with looking at there's issues where there was coal ash that was dumped that was removed from the island, and then it was brought to the US, the coal ash from Puerto Rico, and then the local government in Florida was willing to accept it. Whereas the people of the island were better at being able to resist that type of corporate influence. And even if they didn't like a leader, they were able to create change within it, even if it was not as impactful as it may appear to be. So I think my question is, how do we get people in the U.S. to also have that same level of confidence and change?
It's funny that you ask that, because we have the impression that we don't move. We act like in turning points. It's like every time something big happens, like the Vieques death, and we all knew how Vieques was suffering, the people there, and then we mobilized. There were huge protests. Another case was the outing of the governor. We just got fed up with Ricky Rosselló, which was the governor, and we just started protesting, and every night people were banging on casseroles at certain times, but every night, all people. I live in Guaynabo, which is a metropolitan area, but there, people are not poor here, but then everyone was banging on anything they could find, so that we could say, listen, Ricky, our governor, we don't like you, go away. And he did, and we were surprised that he just left the island. But then what came after was probably worse. So we had to endure it. But we took the streets every May 1st, and people were, students at the university were being arrested. They were being thrown, by the police, by the SWAT teams. And it was a huge repression, especially of independentistas, of independence movement was being persecuted. That's why the independence is not a majority, because they're incarcerated in the US. They're sent to the federal court system for years. I don't know if you heard 1950s. There were some independentistas that started firing to the roof of the Congress. So they spent like more than 30 years in jail. So, and every time one wants to find a job, you find that you have a police record just because you are from left or independence movements. And that's, that's repression. That's just for speaking out, just for marching. So we have taken a toll, but you have to take the street because there's nothing else. Besides all of the things that I said, obviously that's internationally, but practically here in the island, you have to protest. There's nothing else. Because journalism is, they don't let you publish anything. If you go against the annexation, the stateholders political party, the traditional two parties are also disintegrating. Nobody wants to vote for them anymore. There's a 30% vote for the governor right now. I mean, he's governing with 30% of all of the people who voted for him, just 30%. And he's pro-statehood, but then that's questionable that we want statehood. I don't know. I mean, the majority. So, you have to take it with a grain of salt. What you can hear or what you read in the papers, because they're biased. I don't know if I answered the question.
No, thank you. That is helpful. I'd read a book a student had given me called by Nelson Dennis, The War Against All Puerto Ricans. And I think from that perspective, if I compare it like to the U.S. solidarity struggles, it seemed like comparatively, like in Puerto Rico, the struggles were far more severe. And I think it's because of this type of political repression and censorship that exists, that people feel as if they don't have any other choice but to resist. Whereas I think it's maybe easier to placate people within the U.S.
Right. Thank you for that question.
So, yeah, are there any other comments that you would like to make to the faculty? Or should we move on to the Q&A with the attendees? Okay, first question is for Dinorah. Is there any value in trying to reestablish the trusteeship council? Would it be a good use of time and to get justice for Puerto Rico in this way? What are the, and in addition, the second question related is, what are the pros and cons of seeking an advisory opinion in the International Court of Justice? And could the court hold a plebiscite under the auspices of the United Nations?
Okay, the first question about trusteeship council. I don't agree that it should be in place again. There are no other colonies, or very few colonies left. Also, that's why the list of territories is getting shorter, because the trusteeship council used to monitor the list of territories, but then if there are no colonies, because they have either, based on the 1541, they have attained independence, or they have a free association with the metropole, or they have, let's say, annexation, like the French Département, Martinique and Guadeloupe, etc., and French Guiana, I believe. They just chose that path. Actually, MSFC, which was the president of Martinique, has said, or, well, obviously he died, but then he used to say that he was really sorry that he took that path, that his country was suffering more after annexation to France. So, and I recommend his writings very much. The advisory opinion of the ICJ is well, it's also another alternative. It's not non-binding, especially for the US. I don't know to what point the Nicaraguan case was effective. It did show everyone that the US was trying to fund or did fund the Contras against Nicaragua and tried to overthrow the government there. So it's probably an issue to think about. But yes, any avenue that one can find and work to present the case of Puerto Rico and make it public. That's why I always say that the Geneva option is much more open, much more, has more press, has more ways of lobbying in UN Geneva, and it's probably better than being in the decolonization committee, although the decolonization committee has also its good things. And then the plebiscite, It depends. I believe that the 2024 plebiscite is going to have international observers. I don't know the kind of observers they're asking for, because they don't say, but probably not against the US. I mean, so yes, it should have United Nations in place for this plebiscite. But I don't think the US is going to ask the UN for that. So I don't know if I answered all the questions. I believe I did. Thank you for them. I see Kojo there. Hi.
Sorry, I was talking and I was muted. Sorry about that. Thank you, Dinorah, for answering those questions. And welcome back, Kojo. We're glad that you restored your power. We were just getting into some of the questions from the attendees, but if you would like to respond to anything that Dinorah or Nadia said, or they would like to respond to your presentation, this would be a good opportunity for that.
I actually
I
wanted
have
to
a-
ask Kojo a question.
Nadia, and then Dinorah.
Kojo, I was really kind of intrigued about thinking about the kind of the conflict that exists between like these large pharmaceutical companies and then the illicit crops that are coming from different parts of the world, and kind of what actually, like, is it basically the determination of what is illicit and what is not, and how that seems to be somewhat arbitrary, and what are the various capital interests that impact that.
Brilliant. First of all, thank you for the question, and deepest apologies for having to relocate. I wasn't actually able to restore my power. I had to go to a friend's place. So I've moved locations, which is why I took a little bit of time as I shifted from one place to another, so I could go to somewhere with some electricity. This is quote unquote the first world, the developed world. But obviously with what's been happening in Britain of late, you might see that we're dealing with some of our own structural issues. But no, thank you. But to Nadia's question, um, I think that there's this tension between kind of cultivators of what became over the 20th century narcotic substances and transnational capital is one that's always been ebbing and flowing, shifting with different moments. I think, as I tried to allude to in the presentation, a lot of the commodities that we then started to call drugs were really commercialized and globalized in the age of empire with a lot of the same commodities that are now central to, capitalist reproduction, from coffee to sugar, lesser extent now tobacco. But what we're seeing often is that now, with the shift in status, that the people who had benefited from a previous era of psychoactive substances are looking to kind of gamify and monopolize the system around cannabis. There was a CEO of one of the largest Canadian cannabis corporations who said explicitly in a public meeting that, we want this industry to be like tobacco. We want it to not be, small, kind of localized, horizontal cultivators, all around the world, from Morocco to Mexico. We want, 4 or 5 mega corporations that are hoovering up land. When we think about the land and environmental points that you were making, this question around land ownership and land cultivation, particularly within indigenous areas, is something that's right at the heart of this entire issue. And so we see them hoovering up lands. We see them trying to construct the laws in order to maximize their own profitability and to not facilitate this supposedly explosion of wealth generation to actually help correct some of the harms and violences that people endured in the war on drugs era. I hope that addresses some of the concerns.
Dinorah, did you have a question for Kojo?
Yes, I found it interesting, the part about the copyright and patent law and the displacement that would cause communities, which is true. And basically that comment, and if you could say a little bit more about it.
Oh, thank you. Yeah, I think that that ties into, like I mentioned, using the kind of traditional rules and forces of legal property ownership to manage this transition of what was contraband into being commodities. Um, a lot of the kind of financial press will refer to the kind of change in status of cannabis in these different jurisdictions as the green rush. Kind of referencing the gold rush, of the west of America in the 19th century. But then there's the fantastic quote as well, which always says, in the gold rush, the people who make all the money are the people who sell the pickaxes. So not the people who are digging for the gold, but people who sell the pickaxes. And I think that's important to remember when we think who is capturing value in this new market. It's the people who are using property laws to control particular types of plant strains. It's the people who are using, laws around health and safety to own a particular type of testing kit that is now being rolled out to every legal jurisdiction, saying that you have to use this testing kit, or you have to transport it in this particular type of vehicle or this particular type of cooling system. And then we own the monopoly on that. So everybody has to get that. Those are the kind of usages of law, of property, of control, of licensing, of access that these companies are adept at. And I think if we, in the kind of more people-centered international legal community, are attuned to that, we will see, whether cannabis is good or cannabis is bad, it feels like it's coming. It's the 21st century, and whether we're able to challenge that is going to have a lot to do with what we do now, because, in 10, 20 years, it might be too late.
Thank you.
Thank you.
We're going to, Nadia is going to have to drop off now. So thank you so much, Nadia, for your presentation. Really, really important. Forward to having it memorialized on the website along with your article, etc. So thanks so much for that.
Thank you so much. Thank you.
Thank you, Nadia.
Thank you.
Any other comments between Kojo and Dinorah before we move on to to additional questions from the registrants? Okay.
I'm looking forward to hearing from the registrants. That give them some time.
Okay. Next question, and I think this is probably for Dinorah. Has Guam had any luck in achieving decolonization from the U.S. in the last 5 years? Do you know?
I don't think so. I believe that there's a case where they said they were not American citizens, but I don't remember if that was Guam or probably Mariana Islands. I have the footnotes in my or probably the bibliography. I can check it out if you want to, but I don't think they have attained self-government at all.
Okay, and also I just want to take this opportunity to tell people that Dinorah is going to publish a very important article in the review of the International Association of Democratic Lawyers, and that's going to come out soon, and hopefully we can post a link to that article on the People's Academy website. Another question is, what can anti-war, pro-peace, democracy and rights activists do to effectively and peacefully resist illegal wars, ostensibly against communism, drugs, terrorism, and most recently COVID. Since the UN was formed, states have routinely, with impunity, used declared threats from communism, terrorism, drugs, etc., to extinguish and criminalize rights, engage in illegal wars and the use of aggression, seize and destroy lands, water, and other resources, slaughter, displace, and injure millions. So what can we do to struggle against these illegal wars? Kojo or Dinorah, would you like to respond?
Sure, I'll jump on into a little bit of this. I think it's such a insightful question. When we think about the way in which, you know, kind of transitional justice moments have shown that the use of the language around war on drugs, we're seeing this very much in Colombia, was used as, essentially a mask for a lot of counterinsurgents violence, violence upon, communities and, armed struggle groups in different areas, displacing people. We can see the slippage, like I said, between actual, metaphorical abstract war, like the war on drugs, and very real wars, using this cover, using this war against this abstract to contain this space of perpetual violence. I think in terms of what we can do to challenge that, I think organization is always the immediate response. Transnational organizations, I think, are the only way through which we can communicate how a lot of the narratives that are being perpetuated, in the global north, places that are facilitating this violence, are actually impacting communities and people in the global south. And through those organizations, I think there's an ability to place pressure at different points of leverage, whether that's, pressure on legislators and politicians in the global north, whether that's pressure on, arms manufacturing companies. And we've seen, boycott campaigns and, resistance campaigns limiting the ability for the actual transfer of weapons that can facilitate this violence. That could be done through transnational organization, or also just refusal from indigenous or native or, rural populations in the global south, in order to allow themselves to be collateral damage for these kind of global games. And so I think that's, the kind of big picture of things that we should aim for. And, I'm sure there's a lot of people working and organizing in different registers, trying to make something like that happen.
Thank you, Kojo. Dinorah, do you want to add something to that?
Yes, I'm working with a global campaign against impunity of transnational corporations. And what they have done, it's a team, and American Association of Jurists, etc., and Friends of the Earth, and others are working together and they're participating in the draft declaration or draft convention at the UN Geneva to influence also and to lobby the states that, like South Africa was a very big input in that campaign also. What they do is they lobby the, let's say, the friends of the campaign, or of the groups of the NGOs, and then the states present their cases at the floor. And they also, I mean, the global campaign NGOs also, it's about 250. They not only participate as NGOs, but also go to websites and have their own page and post all of the things they do, and the newspapers, they lobby newspapers, then they do everything. So that's one of the things you can do. It's like exchange information between NGOs, support one another, lobby protest. They do protest in Geneva. They go with, different groups and participate in the drafting of the declarations or the instruments, international instruments. And locally, they also participate and do a lot of campaigning, and do a lot of campaigning with the local governments to approve legislation against whatever they find. So those are different strategies one can use.
Okay, great. Thanks, Dinorah. We have another question, and that is, given the silence or inefficiency of UN bodies in the face of even the most terrible crime of genocide in Gaza, are we seeing the death of international human rights and humanitarian law that promised so much, including universal rights and peace?
I don't think so. Can I answer that?
Dinorah and then Kojo, yes.
Yes, I don't think it's dead. It's slow, definitely slow, and it takes like 60 years to form so that a decolonization committee can actually see Puerto Rico. It took like more than 60 years for one resolution to pass without voting, but to pass favorably. But yes, it's slow, but it's getting there, I guess. People can change the institutions. So as I said, if you go and lobby states, etc., and participate, you might see some change.
Kojo?
I mean, I wouldn't necessarily say it's the death of international humanitarian, but I think maybe it highlights a kind of friction and a cut within different traditions of human rights, particularly around when we think about the kind of chronology that connects what's going on in Gaza now to histories of armed struggle and national liberation in the 1970s and 1960s across, across Africa, Asia, Latin America, and then particularly when we think about this idea of decolonization and how has that sat in tension with the institutions of UN human rights. These are kind of two claims of human rights that I think emerge coterminously, perhaps co-constituting each other to a certain extent, but also having very, very marked differences. The human rights that is called out, when Frantz Fanon talks about, remaking the human at the end of Wretched of the Earth, similar to what Dinorah was saying about, Aimé Césaire, Fanon, of course, being one of Césaire's disciples. This is a very different type of human rights than the Universal Declaration of Human Rights, of Eleanor Roosevelt. This is tied to different histories, and perhaps there is there is a re-emergence of a kind of decolonial claim to changing the world that might not be wholly be able to be contained by the human rights system. But I imagine those two kind of tracks will continue to move forward in different and sometimes parallel or sometimes divergent directions.
Yes, and I just want to add a comment as well. It's very, to say frustrating is a vast understatement, to see the World Court, the ICJ, issuing such a strong opinion, ordering provisional measures, and then Israel just thumbing its nose at that and continuing to commit genocide in Gaza. But what it shows to the world is how is what Israel is doing in violation of the ICJ ruling, and how the United States is unapologetically aiding and abetting that genocide, most recently vetoing the fourth Security Council resolution that called for a ceasefire and the provision of humanitarian aid. And now we see country after country testifying before the ICJ in the advisory opinion case on the legality of the Israeli occupation, even though that is not covered well in the corporate media, at least in the United States. It is around the world. People around the world see that. And so we saw not so much lately, but we saw millions of people in the streets marching against genocide in Gaza. And I think we'll see that resurgence again. So I would hesitate to say that international law is dead. It is not doing what we would hope it would do quickly, but also we have the General Assembly, which I think will also pass a resolution under Uniting for Peace, which could have a real major effect in terms of calling for an arms embargo, a trade embargo, kicking Israel out of the General Assembly, etc. And of course, the Assembly is the democratic body of the UN. All 193 countries have one vote. It's not like the Security Council where the 5 permanent members pretty much control what happens, and most recently the US. So I think it's slow, but it certainly is revealing to the world what is called the mobilization of shame, which is a real thing, which is shaming Israel and to an extent as well, the United States in the eyes of the world.
Right.
Are there any other comments that Kojo or Dinorah would like to make, or any other questions? We've had some really good questions here. Or would you like to make a brief closing remarks, Dinorah, Kojo?
No, I think I said enough. I think Kojo might have.
I think just to say, yeah, like how fantastic it is to think about, international law from this more radical perspective, and learning about the environmentalism that Nadia was talking about and the decolonization that Dinorah was educating me about was really informative, and I look forward to seeing more conversations like this through the space. So thank you.
Great. Thank you
Thank
so
you.
much. Now, our next program will be Seminar A. It will take place on Thursday, March 7th, and it will cover the right to a clean and healthy environment. Our speakers will be Marty Schmidt, Richard Harvey, and Mametwe Sebi. And you will receive notice because you've registered for this program. Also, go to our website in the next few days. These presentations will be posted in 3 languages, and links that our faculty have provided to useful articles that amplify on what they discussed today. So if there's nothing further, I want to thank our speakers, Kojo, Dinorah, and Nadia, for your wonderful presentations, and to the registrants, the attendees, for your great questions and for attending. And we hope to see you at all of the future events of the People's Academy of International Law. So thank you so much, and good evening.
Thanks to you, Margaret.
Take care. Bye.
Thank you.